Court does call the case of the people versus Ernest Zazar.
Hey, Judge. Torshio Future Assistant Public Defender on behalf of Mr. Zanzar.
Mr. Simmons.
Zanzar.
Good
Hello.
afternoon. Happy Halloween, man.
Yes, to you too.
I am good to see you, man.
Good to see
I hope for some good news. It's going to work. It's going to work.
Thank you,
Please,
Judge.
please.
I've spoken to my client in the hallway.
Really?
Yes, Judge.
Okay.
He's apparently involved in the LEAD program. He is in that program right now. He said Willie is the supervisor there, and APA Robbins is the contact person there. So we are trying to get some information from them as to how he's doing and his success to see about trying to get this situation resolved. I'd ask for a 2 or 3 week adjournment, please. Is that all that accurate?
Yes, sir.
Wow. Yes, yes, you may. And I know council's got to figure out what's going on with you in the LEAD program and figure all of that out.
Yes.
If I sent you over for a drug test, are you testing at community corrections?
Yes.
You are?
Yes.
Okay, when's the last time you tested?
Last year.
Last year?
Yeah. It's not 2 years ago.
Okay, but you're not currently going over there?
No, not at the moment.
Okay, so let me ask you this.
Yes, sir.
If I sent you over there today, what's that test gonna look like?
I would say negative, meaning good.
Okay, so let me ask you this. Is it gonna come back negative?
Yeah, maybe. I believe so. By the power of God, I believe it's going to be awesome, man. I believe it will be good.
You said maybe it will?
No, maybe not. I believe so.
Maybe not?
I believe so.
Okay, let me ask you this. You been using anything that might show up? Now, hold on before you just out and out answer me. I need you to tell me the truth. Because if you don't, you wanted something good to happen today, but if you don't tell me the truth and something comes back, we're gonna have a problem.
You didn't tell me if you are using something, you're better to tell him now. I'm gonna say no and it come back positively. So if you are doing something, you should tell him. If you're not, that's fine. But tell him the truth.
Hey, Judge, nope, I am not doing no substance.
Nothing's gonna come back. It's gonna come back all clean.
Yes, sir.
Okay, so can I trust that if I pass this matter, can I trust you to get yourself over to community corrections for me?
Oh, yeah.
You know where it is?
Mhm.
You don't need me to have somebody get you over there?
No.
Because you know how my cab system works, right?
Yeah.
Yeah.
You know me, man.
Okay. All right. So what I'm gonna do is I'm gonna put this case aside. You get over to community corrections. We're gonna have to do a quick order. Get it over to them. And I want you to do a drug test, okay?
Yes, sir.
All right.
Cool.
We'll see. And then you need to come back.
Okay.
Okay?
Okay.
I'm gonna walk him out and point him out to the building,
Yes.
try to help him make sure he gets there. So you gotta go there now,
Okay.
take the test, and then come right back.
Okay.
Okay. All right. I'm gonna walk him out now, Judge.
Let's just do it one time.
I'm
Pardon?
gonna walk him out now.
Yes, go for it. Okay. I know I got my 3 o'clock. Let me take a very brief break. I've got to make a quick call and then I'll come back and we'll run through those if Simon doesn't slow me down.
All rise. Hey, everybody. Welcome to American Courts. We got a couple of good ones today. We got Judge Simpson and we've got a Judge Fleischer one that was interesting today. The Judge Simpson one wasn't the one we just watched. That was just to get the show started. Thank you to all the mods. Thank you for everyone out there coming over and watching the show. Linus is getting ready to come over to Houston. I'm supposed to mention that every day, so I'm mentioning it. Let's go ahead and jump into the Judge Fleischer one today. It was interesting. We got Court Addict coming up at 9 o'clock also. I want to get through these two before we jump over there. Let's go.
Docket, we're waiting for an interpreter. I have something that's not on the docket as well.
Okay.
I give you the case number.
Yes.
It is 250-7650. Yes, he's a gentleman, you wanted him enrolled in IOP and SOP. He doesn't live nearby. So Nathan said if he does that, then he can do a PTI, but he has to do all that first. He has to provided my office with the documentation and he has been enrolled. It is going to take some time, as the court knows, but you wanted me to come once he got in so we can get another reset.
So do you have proof of?
Yes, sir.
In the
Yes, sir. Yes, sir. I can show
So
you.
just make sure, if you don't mind showing this to Tori, so we can just verify it's the proper one, and then
Yes.
we'll set you off,
Absolutely.
4 weeks, just to make sure he's
Yes,
in
sir.
compliance with it,
Yes.
and we'll come back and then.
Yes, sir.
How long is the IOP?
Which providers?
Let me look at the email, sorry.
Yes, it's 3 to 4 months.
Right. So what we'll do, Herman, is depending on how long it is, we'll do like a halfway check-in,
Right.
just to make sure that he's doing well.
It is with Better Journey.
Are you familiar with that one? No, okay. We'll sit you halfway,
Sure.
and then we'll
Mr.
reassess.
Ramos is on your docket today, Judge. He's a Spanish speaker, but I
Is it-
understand he's
is that
over.
him?
Yes, yes. But he speaks, but I want to address something. His employer is here with him. They own an event company. Forget the lady on the right. And he's a driver for them. So I was hoping one or two things that with the interlock is just on his personal vehicle, as long as the employer, which she's here to vouch for him, he can drive that vehicle without, as per kind of like he doesn't have a commercial license, but under the occupational license, the statute allows it. But I was hoping the court either does something like that or just put a portable, which is more intrusive than the interlock itself.
I'm okay with that, Herman.
Okay, thank you. Okay, and I'll wait to
Personal, and then on the scram on the other one, so we know he's not, while he's in the other one.
scram. Can that be agency paid to scram? Sure. Okay, cool. Okay, so a portable and a scram. Okay, thank you.
And we'll pay for both.
Okay, thank you. And I'll just wait for the interpreter. And then, so he is allowed to drive as long as, yeah.
I mean, he has a
Yeah,
license
he
and
has a
insurance,
driver's
right?
license. Yes, sir. Yes,
You have insurance?
sir.
Okay.
Yes.
Council.
Oh,
Do
sorry.
you see that, Michael? Do you see who we're talking about? It's Ramos Amaya. So essentially, he wants the interlock only on the personal, not on the work, but we'll also do a scram to ensure that while he's, at no point, he's consuming.
But how are we gonna supervise him driving that vehicle, Judge? We don't know if he's, I mean, there's no possible way that the court can supervise and find out if he's intoxicated or has alcohol.
Scram's on his leg at all
On
times.
his
But
leg,
we
and
can't tell if he's gonna drive, Judge.
he is gonna drive. He's gonna drive his
I
personal
understand,
vehicle
but
and the vehicle owned by his employer that she's here to vouch for the court, that he's not, he's not going to be driving with any alcohol in his system.
You can't vouch that he's not driving, he's not gonna have alcohol in his system,
Yes,
Judge. The only way we can
pretrial
properly
is vouch.
supervise.
I'm not asking pretrial to vouch for it. Her employer, which is a reputable citizen, and she's here and here to
And
tell
that
you.
vehicle is he driving for? What does he do?
It's an event company, so it's those trucks that, they bring, the tents and everything for events.
I would be against it, Judge, just because we can't coincide the scram to when he's driving the car. So he could drink a beer and drive, and the car would activate and we would have no idea.
It's
He would get
excessive
a
what they're asking for
BVR
on a first
eventually.
offender.
Let him-
I'm sorry, I thought he was done. Sorry.
He would get a BVR eventually, Judge, but there's just no way that the court can properly supervise him and ensure the safety of the community if we do it that way. I understand counsel's position, but I would disagree.
This is his livelihood, Judge. I mean, and he's such a great employee that it's very rare, as you know, when an employer comes
absolutely.
in, that's how,
So, but why is it that the device can't go on the work vehicle?
because it's a company vehicle, it's a,
It's a vehicle, though, right?
Yes, but-
Theoretically, it could, right?
but other employees drive that as well, Judge. I mean, it's just to put that burden on the employer is a bit excessive to have, that lady is a small business owner to incur that. And then you're gonna have other people driving it, and it can come back to Mr. Ramos's DVR as well.
No, because
No,
it takes your picture.
Yeah,
So
but
you
you
know
still-
If someone else, is consuming, which they shouldn't while they're working regardless.
No,
right?
I understand, but it's just excessive where he's gonna have the scram and he's gonna have.
I'll take it off.
I'm sorry?
I would take it off. I wouldn't, there's no need for a scram at that point if we put it on the work vehicle, right?
So,
I don't know, Tommy, look, we're putting the cart before the horse because we haven't even found PC on it yet.
no, okay, I mean,
Let's really address it, and then I can always talk to her, and figure out, there's always a solution that can be worked, always.
okay, I'll just wait for the interpreter.
Do you have this is talk about?
No, I haven't yet. That will confirm that whether that be insurance company has made a decision on accepting liability. So I'll talk to her earlier this week as I agent credit.
I can't admit it before. Morning.
Or Eric Ramos Amaya.
Yes.
Order in the court.
Mr. Ramos Amaya, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Yes, sir.
Okay.
On October 28th, 2024, the officer was dispatched to Hempstead Road in reference to a person down. Upon arrival, the officer met with a witness who advised that around 8:50 p.m., she observed the defendant's motor vehicle to be parked in a parking lot at Speedy's Fast Track and observed the defendant to be passed out
It's a safe place to stop, very well
in the
lit.
driver's seat of the car. The witness also observed the vehicle running. The witness attempted to wake the defendant, but he was non-responsive. Upon the officer's arrival, they also observed the defendant to be unconscious behind the wheel of the car with the vehicle running. Upon getting the defendant to exit the vehicle, the officer observed a moderate odor of an alcoholic beverage, glossy eyes, slurred speech, and a swayed stance on the defendant's person. The defendant admitted to drinking. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 2 out of 4. The DIC was read and the defendant consented to breath. The results were 0.228 and 0.221.
So you just found him there in the parking lot.
It was reported as person down. There was a call that came in. He was unconscious.
What kind of evidence is there that he was driving at any time? How do we know that he was not just hanging out at Speedy's and drinking
Well,
like
you're right.
crazy?
The officer found him unconscious behind the wheel with the vehicle still running at the time. And
I understand that. I understand, but maybe it was for warmth, so he could breathe. What evidence is there of driving? Do you have anyone that sees him driving? Do you have?
Your Honor, the witness just sees him parked already with the vehicle running, and that's what.
I
Yeah,
understand.
and that's what we have, is the call came in.
Michael, do you have anything else?
Judge. So we have defendant unconscious in the driver's seat and the court's issue.
He's in a parking lot of Speedy's. If he's in the middle of the road, unconscious, that's something, right? If he's in the middle of nowhere, unconscious, and he had to have gotten there somehow, okay. How do we know he wasn't inside speedies.
My opinion is the court is attempting to litigate the issue. This is probable cause. All we have to show is that probable cause is met in the case. He is unconscious in his driver's seat of the vehicle while it's on. That, in the state's opinion, is more than enough.
Driving
to show
while intoxicated. It's not sitting in a
it's
car. while
operating a
intoxicated.
motor vehicle.
What proof do you have of operation?
I can provide you, if the court needs case law citations of operation and what is considered enough for operation. If you give me like 5 minutes, I can get
Take
that
your
for
time,
you.
no
Okay.
rush.
Thank you,
Really,
Judge.
we got until the end of docket. Show me something that says just sitting in a car,
Yes,
you
Judge.
know, with it on.
It's not a public roadway either. It is, yeah, it's a pub.
It's a public place, Judge. There's multiple case law.
I get that, but my issue is, how do we know that he wasn't inside speedies, just going nuts on alcohol, and he just goes back in his car and just sitting in his car to sleep it off? I don't know that. We don't operate on hunches, right? That's what I'm saying, like, if he's,
Assuming that the state is correct in their case law, it still doesn't address your essential question. I mean, let's just say what they're saying for operation purposes. It still doesn't address that at the time that the officer said, found him, he was at 0.08 or higher, or any operation at all while he was intoxicated.
I just want some proof of operation.
I can get you the case law.
That's,
Yes, Judge.
I'm not asking much. All right, take a seat, Mr. Ramos. I'm not ready to rule yet. Hey, can you scissors?
Can you send me the case, please? See how I can stick. He says he has it. If we can send it.
He's ready to go?
Right, so there's multiple.
Now we lost the interpreter.
Oh, okay.
Oh, sorry. Okay. What's the, can you send me the?
So it's Anderson v.
Oh,
State.
can you send me the?
Yeah, I'll email it to you.
Anderson v. State, you say?
Yes, Judge.
What's the code?
I'm gonna send it to you right now. What is his client's name? His client's name is. Perez. No, that's not. I'm sorry. What's your client's name?
Ramos. Is that,
This is
it's the unpublished opinion?
Hold on.
maybe I'm looking at the wrong case. This is a sexual assault? No.
No, I think it's the 2010 case. George
2016.
Anderson,
It's a 2016
It's
case.
2016.
what's?
2016, you
I
say?
just sent it, yeah. I'm just trying to get the closest to what we have here in this case. There's multiple cases that,
Yeah, it's an unpublished opinion you're sending us.
sure, but the facts are very
Yeah,
similar.
but
It's not-
it's an unpublished opinion. so-
Okay, I mean, I can, if you want to give me more time, I can get more case law, but I mean, this is just something that I found in 2 minutes that is very similar.
Take your time.
Okay.
There's really, there's
Just
no rush.
email
We
me, I'll
have
come back.
until,
Got it.
no,
So give me some time, I'll shoot you an email.
there's just no rush. And then too, Herman, if you find something.
Yeah, approach on Ramos again. I don't know if you've taken a look at the cases that the state provided. They're very distinguishable, both of them. On one, the Prego case, someone actually sees the driver driving at some point, and then.
I've read about 17 different cases.
Right, and then the second one that the state has provided, the driver self-admits that they were driving at some point, and in both cases, they have the seatbelt on, and there's other evidence of driving and operation, which is distinguishable. In this case, there's no facts that he had a seatbelt on, or he was seen by anyone driving, or he ever admits to driving. So their reliance on those cases are unfounded because it doesn't fit this fact pattern that we have before us today.
So Judge, the first case that I'll refer you to is Prego versus State, which in that case,
Do you email it to me by chance?
I can send you an email right now, Judge.
That's the one he's seen, the person is seen at some point.
Can I make my argument, Counselor?
No, I thought you were emailing, yes.
I am, but let me
while
at
you're
least make
emailing,
my argument.
I wanted to give him a synopsis of the case.
Well, let me make my synopsis and then I promise you I'll let you respond.
I was in back reading, I must have read like 17 cases. God. I don't think that there was any case that supported your position. You know, I must have gone through at least 17 to 20
Well, they have to
cases,
prove
you know?
it's a totality of circumstances. Just behind the wheel is not sufficient. They have to provide. Okay.
So let's go to Kenneth versus State, Judge. I sent you an email. Did you receive it?
Okay.
Okay, so in that case, I'm reading just word for word from the case. Courts interpret, quote, operation of a motor vehicle very broadly, and they cite Prego versus State, which is an appellate case. They cite Smith versus State, which is an appellate case. And they say, quote, while driving does not involve operation, operation does not necessarily involve driving. So we have to prove operation of a motor vehicle. Operation does not necessarily mean driving. It states any action that is more than mere preparation towards operating a motor vehicle falls under the definition of operating. So in this case, we have
Does the fact that you turn the keys onto the car,
is enough, Judge.
That's his opinion. There's no case law that
That's
says
what the
that.
case law literally
You're saying
states.
mere
word
preparation.
for
like
word.
conspiracy, right?
Yes.
The law
Or
of
law
conspiracy is, it has to be more, like.
So
an
what did he
overt-
do other than start the vehicle? There's nothing more that there's nothing more than mere preparation. It
And
was a
that's
hot
what-
day, and the Prego case, people see them, they have the seatbelt on, which is more than mere preparation. They don't show the seatbelt on. In the other case, the Houston case, it self-admits that they were driving. In this case.
Yeah, I mean, that's right. We're not gonna, if there's a self-admission, that's.
Right, and
we're
those
not
are
working.
what they relied on. The two cases, on the second case that he's quoting, or he showed you on the site, that person, that defendant self-admitted. And there was also other evidence
Have you found-
beyond mere preparation.
You found any case law to support the position, though?
Well, what position? It's their burden that there was more than mere preparation.
No, but I've asked you to see if you, because I went in back and I literally read through 20 cases
Yes,
and I can't find any case that supports the proposition that that's not operating.
well, what they have to show is more than mere preparation. Having your vehicle on by itself is not beyond mere preparation. That is just mere preparation. They have to show either they had a seatbelt on, or the car was in neutral, or something beyond just in the car getting AC on a hot day. I mean, that,
If you can.
And Judge, there's no, you're right.
And, you know,
Right.
I'll certainly look.
I mean, that's what everyone, our legislatures tell us. If you feel like you should just stop and pull over, and that's what he did. And then someone comes at a later time.
There by your admission.
No, I'm not, because if you stop, turn off your car, and then you get hot because you're in a hot vehicle, turn it on, that's not operation. That is not beyond mere preparation.
Where are you getting that from? How are you saying that's not operation? What is your citation for that?
You just stated in your case law that you have to prove more than mere preparation.
Okay,
My opinion, my
love
statement is, all you have shown is mere preparation. That's it.
but
You haven't gone beyond mere
but to be
preparation.
clear, you don't have any legal basis for your opinion.
Yes, your opinion is right there when you said it's a totality of circumstances and you have to show more than mere preparation.
And I think the fact that,
There is no case law that says that.
find me something.
Well,
different.
that case says it. That case says just turning on your vehicle, you have to show more than mere preparation.
That's not what it says. It doesn't
You
say
read
just
that.
turning on your vehicle is not enough. That's not what it says.
Is that Prego?
This is Kennett versus State.
And then that case is also
I'm gonna
distinguishable.
read it exactly what I read to you just a couple of minutes ago, Judge.
Okay.
Courts interpret operating a motor vehicle very broadly, and they cite multiple cases. While driving does not involve operation, operation does not necessarily involve driving, stating that any action that is more than mere preparation towards operating a vehicle falls under the definition of operating. So any action that is more than mere preparation towards operating a vehicle, that does not state that doing this with a key and turning on the car is not more than mere preparation. Our position is that that is more than mere preparation. You've put the key in your car, you've activated your vehicle. That is more than mere preparation. You're attempting to operate the motor vehicle. You don't need to be seen driving the vehicle to satisfy operation under this case.
I want to be clear. I'm not saying that it has to be seen, but they're stating exactly conversely what I'm saying. You're asking me to show you where just putting on the key is not operation. So I'm asking for them to prove just putting on the key is mere proper preparation, because they're stating a case where the defendant admitted to driving, okay, in that case. And that is in the facts of the case, and that's what the court relied on, that in addition to this law, that he admitted to
You're
driving.
saying in Kenneth, he,
Yes, that
Admitted
defendant
operation?
took the stand and admitted that at some point she operated the vehicle. In the Prego case, someone saw that person driving the vehicle. Then they saw him at a later time.
They admitted to driving at an earlier time.
Yes,
They didn't
yes.
admit to driving then.
Yes, that's
Can you-
correct.
can you point to me to at least one case that shows me where they have found it not to be operating?
No, but I'm also going to state this to the court. Can they show you one case where just having the key in the ignition is more than mere preparation? They haven't shown you that.
I went through 17 to 20 cases, Herman. I haven't found, I looked.
Either way, I bet. Either way, either way. So it's up to the
I
court's
didn't find
discretion,
any, yeah, I didn't find anything to support the position.
theirs or mine.
So let's do this. I'm gonna find it for now.
Okay.
Go back, do some research.
No, there isn't. I'm very clear on the law. They have to show more than mere preparation. And they haven't in this case.
According to the case law, they have that.
No, I disagree, Judge, because because they haven't shown that starting your car is more than mere preparation.
I appreciate it, but the law says differently, you know? Come up, Mr. Ramos. Oh, do we have a translator or no?
And then we have the second issue, Judge, where we have a disconnect about, he
I know, and
cooperated.
I'm gonna bring her up to talk about it.
Yeah, I mean, that's just ridiculous on a first-time offender to have where he did the right thing, even in the courts, pulled over and safely, and it was not a danger to anyone in this case, to have two interlocks put on one on a personal vehicle, on a commercial vehicle, where our legislature stated for an occupational license, where someone's already been convicted, they can have it just on their personal vehicle and not on a commercial vehicle they're driving. So it's just excessive to have two interlocks, especially where she has multiple vehicles that he's gonna have to drive, where he's the manager of the events place, and he's all over all the time driving multiple vehicles, multiple trucks for him. And she has a strict policy of no alcohol.
Let me get the translator.
Sure.
Okay, Mr. Ramos, I've been.
Order in the court, please.
I am gonna find that there's probable cause to go forward.
Declarar que hay causa probable para continuar con su caso.
I am ordering you as a condition. of rebuttal. Well, let me ask you this. Are you a United States citizen?
No. No.
Are you in this country with or without permission?
Judge, I always tell my clients that it's not to answer it because you're asking them to admit to a potential criminal case.
Okay.
Yes.
Okay, está bien.
I want you to understand,
Quiero que
one thing.
entienda de que
Not in
una
this
cosa, si
country
no
with
está en el país
permission.
con permiso,
You go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody first until this case is over with and then shipped off to immigration. I don't know what your immigration status is, but if you're not in this country with permission, be very careful. Do you have a Texas driver license?
licencia de conducir de Texas.
Do you have liability insurance in your name?
Yes.
Okay, you may continue to drive, but I am ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I will put you in jail. You will not get any more PR bonds. Now, I will order you to obtain an interlock that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Your counsel has asked me not to put one on in the work vehicle, but understand that could be a huge liability on your part. If there's an accident and they learn of that he has an open DWI, it could be potentially disastrous to your business. So you need to consider this when you're out there, especially if he's driving and he has an open DWI, it could be very disastrous.
Are you saying that he's allowed to drive one of her vehicles without an interlock?
I know that you are against this, right?
Yes, Judge.
What I will do is I'm also scram monitor on your ankle, so I know that you're not consuming alcohol at any time. And I will not put it on the vehicle,
Thank you.
okay? But I want you to understand, these machines are extremely finicky. So you better darn well know anything that you put in your body before, because I don't care what it is, if it's a tequila lollipop, if it's NyQuil, if it's hair dye, if it's isopropyl alcohol, if it's Jesus comes down and tells you to break bread, I don't care what it is. The slightest, faintest, most remote positive alcohol, you will land in custody. Do you understand? Be careful, especially with your insurance, because if insurance knows that if your insurance doesn't know that he has an open DWI and it gets into an accident, they may deny liability. So, you need to really put everyone on notice, because it could be a very big issue. Now, good job on having a lawyer. You've got a junkyard dog for a lawyer who we respect very much. It is your responsibility to stay in touch with Herman. He will tell you if and when you have to come back to court. If Herman tells me that he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Just stay in touch, do not pick up any new cases, and don't consume alcohol. Do you have any questions?
No.
I will also pay for the devices so that there are no issues, Herman.
Okay, thank you, sir.
Do you have any other issues? that
No,
you
sir,
have?
not at this
Okay.
time.
All right.
All right, so I'm gonna go ahead and bring up politics so we can get it through the air. It is important that you voted today. It doesn't matter who you voted for; that's your business. People want to jump into comments and say stuff. I don't know where the win is in that. I don't know what the people's goal is, but we do appreciate the comments. It does help the algorithm. Yes, Cass, I watched Judge Middleton's today. Yeah, I was an hour-long video. I'm working on editing it. I can't do it on the live. I really wish I could have done it on the live. That was the most important case that I saw today. But I'm going to make it into a video and try to put it out that way. So, but thank you for mentioning it. Thank you for bringing it up. We're going to jump over to Judge Simpson. He had a hell of one today too. We're going to jump over to that one, and then we'll get to Court Addict with ATX Alley. All right, here's the Judge Simpson.
Your name, sir?
Stephen Chatain.
All right. We're here on the money claim. Have the parties had an opportunity to try to talk to each other about it, or?
Judge, I've tried to talk to Mr. Chatain about this. He really didn't want to hear what I had to say. He said, I just want to let the judge decide.
Is that right, sir?
Mostly. He never has offered a settlement. He's never offered a settlement.
Okay, what's the primary part of your claim?
They nearly doubled my rent, saying I didn't meet the friendship suite requirement. As far as I've been able to tell, no such document exists. They have not produced it for me. They have not produced it for court. And because of that, I feel that they overcharged me for a year, saying that they couldn't find me a roommate and want to charge me for a 2-bedroom, 2-occupant for the full cost.
Okay, so let me just make sure. You moved out. You moved out.
I'm sorry, Lord.
Have you moved out yet?
I've made arrangements and we should be out by the 25th without any problem.
Okay. So you're claiming that you overpaid them.
Yes.
How much are you claiming you overpaid?
December of 2022, my rent was $2,120. Starting in January, they increased it to $4,081. That's $1,961 per month times 12 equals $23,530 in overcharge.
Can I ask a question then? Why'd you pay it?
It's a term, it's automatically charged to my account and I have a conservator. That's where I got this report on monthly payments.
All right. So you have a conservator?
Yes,
Do you currently have a conservator?
yes. He's negotiating my new residency as we speak.
Okay, so let me ask you this. Did your conservator say anything to you about the amount of rent you're being charged?
Well, 3 months after the fact that they started charging me and called me and said, do you know that they doubled your rent? And I said, no, but I'll look into it. And he said he didn't feel it was right. And he wished me well in this negotiation that's about to happen.
You have a position on his claim, other than you don't owe him anything.
Yes, and I'm happy to fill in a few of the gaps in the facts here, Judge. So, Mr. Chatain's lease is a 30-day month-to-month lease. And it states in the lease that upon providing written notice, American House can change the rent. That's what they did here. They provided him written notice that they were increasing his rent. And the reason that they increased his rent, he's correct. His apartment is meant to be a shared unit with a roommate. And because of the condition of the apartment, they were not able to rent it to another tenant. They had given him warnings about this and saying, can't rent this to somebody else because of the condition of the apartment. Then they provided him with a notice and they said, if you don't get the apartment in condition where we can rent it to somebody else, we're going to raise your rent effective in January. That's what they did. They were contacted by the conservator after the rent went up, and they explained to the conservator, here's the situation. We've increased his rent because we can't rent the bedroom to somebody else. And the conservator said, okay, I understand. And didn't stop the ACH payments, continued to allow the money to be drawn. After about a year, Mr. Chatain got the apartment in the condition that American House decided it was satisfactory to try to rent it to somebody else. And they reduced his rent back to the original amount.
Because they were able to rent.
They still weren't able to rent the room to somebody else, but they had asked him in writing, we want you to do A, B, C, and D to get the apartment in a condition where we believe we would be able to rent it. Because of other issues, they were not still able to rent the apartment to him, but they followed through with their side of the agreement and reduced his rent. Yeah.
Is that correct?
No,
Okay, of course not. So what part of that's not the case?
it was not a question of them increasing the rent as in a normal annual increase in rent. They changed the terms of contract from me living in a 2-bedroom, 2-occupant suite to saying you're now renting the whole
Mr.
suite.
Chatain, yes, but that was their claim, wasn't it?
Well, they never provided.
Well,
me
hold
with-
on,
I'm
hold
sorry.
on. That was their claim. It was supposed to be a 2-occupant suite.
Right.
Okay.
I had 4 roommates before this over the last 10 years. So,
Okay.
and they've all complimented me on how nice it looks. So it boiled down, in my opinion, it boiled down to the question that I had masks from all over the world on the walls, and I had a very demure nude. And none of my roommates.
Demure what?
Nude. N-U-D-E, nude. Naked woman.
Okay, I'm presuming,
Yes, and they.
presuming a statue.
I'm sorry.
Was it a statue? of a nude woman or
No,
actual
just a
nude
painting,
woman?
Just a painting.
Okay, all right, thank you. Go ahead.
Well, they demanded more room and they made me throw away my leather sleeper sofa because they wanted more room in the room. No one had ever complained about this.
Mr. Chastain,
Yes,
you would agree that there was supposed to be another occupant in the room?
absolutely. They
Okay.
admit that I asked for a roommate.
Okay,
continuously.
but hold on. They then did they send you information saying they couldn't lease the other room?
No,
So they never sent you anything?
I have included
I
everything.
guess I didn't ask you what you included. Did they send you some notification regarding what you needed to do so they could rent the other portion?
No,
Never.
nothing. After
So-
repeated requests.
So if I set this for trial and they have that, you might admit that you don't have a claim.
Of course, but they've never provided it in the last 2 years.
Okay, so
It doesn't exist.
at some point, Mr. Chastain, your rent goes back down,
Right.
right? So why did it go back down?
Because I threatened to sue them for their mistreatment.
So they just lowered your rent.
Well, they made me do a number of things because they were going to already increase rent another 10%.
So what were those things they were asking you to do?
They made me remove most of the artwork from the living space. They made me clean off my own dining room table where I had a sculpture. They made me throw out my couch.
But hold on, this dining room table, the dining room table would have been shared by the dining room area would have been shared by the occupant.
Everything that's in the apartment is shared.
So they asked,
Silverware, you name it.
okay, so they asked you to remove
All the stuff that was on the
the dining room table, so that if there was somebody else there, they could use the dining room table.
And the prior
Exactly.
roommate did use it instead of going down to the dining room.
Okay. So what else did they ask you to do?
They asked me to remove half of the material in the linen closet, which was easily done. They made me move.
So that the other tenant, if they were there, could have space.
Right.
Okay,
They made me remove half of the material that was in the shared closet. It had never been a problem before. It had accumulated for 12 years, 10 years back then. And I was able to do it, but I gave away, I would guess, thousands of
Mr.
dollars
Chastain,
worth of stuff.
Chastain,
Yes,
have you listened to what you've said to me?
you asked me to go on.
No, I know, but have you listened to what you've been telling?
They out of the blue produced
Mr.
an
Chastain,
article that
Mr.
said,
Chastain, Mr. Chastain.
yes,
How did you get notification that they needed you to do these things?
I never got notification without asking for something in writing. It shows that these friendship suites exist and what the requirements are. They gave me a list of things that were particular to my room, and it's not a general policy.
Mr. Chastain.
Yes. I'm sorry, if I
How-
speak loud, it's because I've got these.
I understand. How did you know what to do?
After corporate officers came out and said, this isn't a friendship suite, and I asked why, and they said it looks lived in. That's all they
So
said.
let me ask you this. When they talked about, let's say, the dining room table,
Yeah,
did they tell you why you needed to clean off the dining room table?
Well, half the table was covered with my current mail and they wanted everything off the table.
Mr. Chastain,
I'm sorry.
you need to answer my question. Did they tell you why you needed to clean off the table?
In case my roommate wanted to eat.
Yeah,
And I did.
okay. But before that wasn't the case, right?
Not after my last roommate left. I told you.
Okay,
My mail.
all right. So let me ask you this.
All right.
Did they tell you why they wanted you to empty out half of the closet?
Because it belongs to the other person. My potential roommate. And that was very
So,
difficult
Mr.
to do.
Mr. Chastain,
Yes,
if you're paying, let's say 21, what was it 21.20 for a space that would, if the landlord could use it, would cover twice that amount. Right?
I didn't quite catch that.
They had another person in there, presumably that person would be paying the same thing that you pay,
Yes.
right?
Yes.
Okay. So, Mr. Chastain, if you're using the whole thing,
I'm not.
don't. If you're using the whole thing, then don't you have to pay for that?
But I'm not using.
But I didn't ask you that. If you were, let's put it this way, listen to my question.
All right.
If you were using the whole thing, you would agree, we could all agree that you would have to pay for it, right?
Yes, but I'd have.
If you're using it to the extent that they can't move somebody else in, you would be required to pay that, wouldn't you?
Yes.
Okay, I'm gonna tell you, as I'm looking at this, that's what happened. Follow me, Mr. Chastain. Here's what the deal is. You're using the whole unit, basically.
They're saying.
Whether you're admitting that you did, because you're admitting that when they notified you, you basically started putting it back in shape so they could put somebody else in it. You're using that property. And so if you're using it, Mr. Chastain, you have to pay for it.
They wouldn't tell me what I had to remove. I asked for 9 months, soon as it started happening, and they refused to give me something. I talked to corporate, they said it looked lived in. They finally gave me a list in October and said it had to be done by.
But I thought they didn't give you anything.
After I requested it and after corporate came and announced that it was not a friendship suite. They did produce after, I believe, 10 months. So they were.
So before then, Mr. Chastain,
Yes,
before then, you were just paying this amount of rent, right?
I was paying.
And had no idea why you were paying.
I don't quite understand what you're driving at. Could you give me a little bit more so I can
You
respond?
were paying twice what you had before, but had no idea why.
No. Everybody that lived with me thought we was
I
very.
didn't care about everybody else living with
Uh,
your rent doubles.
Yes,
Your conservator knows,
yes,
right?
yes.
Your conservator tells you, right?
He tells me when the increase went up,
Okay.
that's all he told
And-
me.
And you're saying you paid it and didn't know why?
That is correct. It was because I wasn't meeting the requirements of a friendship suite, and they have never
Hey,
provided the
Okay, that's
requirements for a friendship suite.
Mr. Chastain. Let's get off of that phrase friendship suite. for a
Well,
moment.
it's key to this, because.
No, it's not.
All right,
Because what's key to it, I don't care what you call it. What's key to it is there's supposed to be somebody else there.
Yes.
And there can't be because you are using the other part of the apartment.
A tiny part, nothing in its bedroom or anything.
But you're using it to the extent that they can't put somebody else in, Mr. Chatane.
Well, that's not true because I've had 4 roommates and nothing has changed.
Judge, this is the letter that Mr. Chatane attached to his own pleadings. It's dated November 30th, 2022. And
Which exhibit?
it's exhibit I to his own pleadings. Maybe it's
You said it's November 30th?
November 30th, 2022.
Got it.
It says, "Dear Steve, as you know, you currently reside in a friendship suite. We have had conversations in the past asking you to clean out the apartment in order for someone else to be able to move in. At this time, we feel that we can no longer offer this as a friendship suite or even be able to show to prospective residents due to the smoke odor, lack of space, and condition of the apartment inside and outside. All the above are considered lease violations." Then it goes on to indicate how they're going to raise his rent, and they give him until basically the end of December to try to get this resolved. Starting January 1st, his rent's going to go up. So they put him on notice of this, and he attached it to, so obviously he had a copy of it because he attached it to his own pleadings.
See it?
Well, from my point of view, they're making a lot of claims. There aren't.
Mr.
I see the
Mis-
letter here.
Okay, and Mr. Chatane, you would agree with me?
No,
That-
not at all. The
Okay.
smoke odor, lack of space and condition of the apartment inside and out is utterly false.
And why'd you?
And they took my apartment.
Mr. Chatane,
Yes,
you told me they never sent you anything.
with regard to why I'm not meeting a friendship suite.
Mr. Chatane, what does that letter say? Doesn't it, doesn't it?
I'm sorry.
Yeah, that was a question. What does that say?
I don't really know how to respond. You know,
Well, you're gonna,
I've lived here 10
you're
years.
going to need to respond to my question.
all right,
What does that letter say to you?
it says my apartment doesn't meet the requirements of friendship suite and therefore we're doubling your rent. That's what it says.
And it tells you why.
These, if you look at these,
Mr. Chatane,
smoke over.
Mr. Chatane,
I don't smoke.
it tells you why, doesn't it?
They never gave me anything in 9 months requesting what I need to do for a friendship suite. These 3 things, you know, that's their opinion. Fine, show me the friendship suite requirements. And they didn't have any. They don't have any now. They made up this list particular to me. It's not a policy and it's not in my lease.
Judge, what I would say is that it's not relevant whether or not any of that stuff is in his lease. What is in his lease is that they have the right to increase his rent with 30 days notice,
I-
and they gave him the notice.
Yeah. You realize that, Mr. Chatane?
Well, they increased it. I know that. 9 months, they didn't tell me why. These are not reasons.
But hold on, Mr. Chatane. Understand something. They could have increased your rent and not given you any reason why.
I'm sorry?
They could have increased your rent and not given you any reason why. On 30 days' notice, they could increase your rent. They don't even have to tell you why they're doing
Well, that would wind up in court too, then I guess.
And you'd lose,
I'm sorry,
and you would lose.
that's why we're here.
Yeah, so you can lose.
No,
Oh.
to settle the matter. If you say I have no claim, fine, I'll
Well,
stop here.
I'm gonna tell you, I don't see where you have a claim. You're telling me things that aren't true. You're telling me they didn't send you anything saying what they were doing. Do not interrupt me. You told me that. You told me that you did not know.
That I was in a friendship suite. I did not know. In the letter I sent to you, I said, I never heard of it before. Nobody I talked to ever heard about this. If it had been in the lease or if they'd sent me the requirements, look at what they asked me to do compared to these 3 vague things they listed in this letter. Look at them. They're specific things. You can't have your toothbrush and toothpaste on the sink. They just made up a bunch of stuff. Ask them to produce the document that says what a friendship suite
Mr.
is.
Chastain,
Because I would have
Mr.
agreed to
Chastain,
it.
Mr. Chastain, why do you have a conservator?
I don't. I had some mental issues in the past. 10 years ago, 12 years ago. And at that time, I was not capable of paying my bills. So the conservators worked out. It's not horribly expensive. And he, just like American House takes care of all my needs for the telephone, my conservator took care of all of my needs. So, you know, I don't have any problem having a conservator.
That conservatorship is still pending.
I'm sorry?
The conservatorship is still pending through the court.
No. I've had the conservator court approved 12 years ago when I first moved into American House.
Was that approved through Washtenaw County?
I'm sorry?
Was it through Washtenaw County that the conservator was appointed?
Yes.
Who initiated the petition for appointment of the conservator? Do you know?
I talked to the manager then, and then my conservator took care of the paperwork. I signed the lease back then.
No. I'm talking about the case where you had a conservator appointed.
Yes.
Who initiated that case?
Well, I asked the court to appoint a conservator for me.
So you started it?
I believe so. I don't know who else would have. That was a long time ago.
And I'm just gonna tell you this because have you talked to your conservator about this?
Yeah.
Okay, let me ask you this. You don't manage your financial affairs.
No.
And so did you tell your conservator that you were filing a claim that might affect your financial position?
Might affect it? How so? He knows I'm here. He asked if he should be present.
And what did you tell them? Tell them.
I thought we were going into your chambers and I told him I didn't think it was necessary.
Oh, I think it's absolutely necessary.
Can I ask why?
Because you don't manage your own financial affairs and you filed a suit for money damages.
I'm not a stupid man.
I never said that.
I suffered for a year because they wouldn't tell me what I needed to do.
Chastain, I'm not calling you stupid. I'm not saying anything about that. I'm just pointing out the fact that you do not manage your own financial affairs.
Correct.
And there is an individual that does manage your financial affairs. What you have filed here has an impact on your financial affairs. And so your conservator should be involved.
Well, he told me just yesterday that if I were to prevail, that the amount should be made out to me with Jim Baker as a conservator.
I know. What happens if they file a claim and you end up owing money?
I asked the court to talk to my conservator. He takes care of my financial affairs.
Said you had a conservator for 12 years?
Yes.
And he knows that you filed a counterclaim.
Yes.
Did your conservator say anything about maybe you having an attorney?
No.
16.
Monday, 16.
No, that's fine. That will work. Because if they have to file the red, it can be signed and executed. 16.
Yes.
Mr. Chastain, have you thought about getting an attorney?
No.
Okay. I think that you might want to take a look at it.
If you turn me down,
No.
stop. I don't see any reason to spend more money on this issue. If they think that they didn't lie by saying I didn't meet the requirements of this word I'm not supposed to use, where's the document? That's all I ever asked for, so I can comply with it. And as it got down to the end of the year, they started making demands and they were going to increase my rate even more. So I worked very hard for 2 months to meet their requirements. That isn't a policy. It was specific to my place. And that's not a policy. They say they could have said, we reserve the right that you meet these, and everything would have been fine. It never would have arisen. I have no more furniture in my apartment now than I did when I moved in 12 years ago. I've had 4 roommates. How can they say that I don't have enough space?
Okay.
Anytime any of them ask.
Mr. Chastain,
Yes.
you told me that the apartment was supposed to have another person.
Yes.
You've also told me that you had things in there that would prevent another person from having basically half of that unit. Why you had it, I'm not even worried about that. It doesn't matter to me. They could not put another person in. They then sent you information of what they saw as lease violations and further informed you that they were going to raise your rent.
Yes.
You may not like it, but I don't see anything that they've done that's wrong.
It seems to me that if they claim that I don't meet requirements and they have no requirements on writing, I don't see how that's legal. I have a real problem with that.
Okay, so this is the final settlement conference. You want me to set it for trial, but I'm going to advise you of something before you answer that. They can ask the court to impose sanctions for the filing of a frivolous claim.
If you say so, I don't consider this frivolous. I've got the documentation right here.
Okay,
Yes.
I'm going to advise you that they could ask me to do that and to basically impose sanctions for their attorney's time and for everything else. I would also tell you that I don't see, based upon listening to you, based upon looking at the documentation, that you have a colorable claim in this case. But if what you want me to do, if you want me to set it for trial, I will set it for trial.
I was hoping, and I was under the understanding that I asked for a summary judgment in this matter, so it would end now. Either I win, lose, or you demand that we have arbitration. And that's fine with me. I don't want to spend any more time with this. I think I've been wrong. They've treated me.
And what I would suggest, because they haven't made a money claim against you, what I would suggest, Mr. Chastain, is that you might want to consider dismissing this case against them.
If that's your advice, I'll.
No, yeah, you know what, Mr. Chastain, you don't have to. I'm going to make that suggestion to you. I'm telling you, I don't see anything that gives you a colorable claim.
I would like you to just drop the case.
Do you want me to dismiss the case?
Yes.
The counterclaim. Any objection?
I have no objection to the counterclaim being dismissed.
Counterclaim is dismissed. I'm going to do that with prejudice as to the counterclaim. Mr. Chastain, the only thing that I would issue, because the possession issue, they can issue a writ to have you removed. You're going to be out by the 25th, you think?
Absolutely.
Okay, very good.
Judge, do you need me to file anything with the court with regards to the dismissal of the counterclaim? Or the court handle that?
Would you just prepare an order, and maybe you could find a handwritten one that just says defendant is dismissing his counterclaim?
Okay.
I'm gonna go ahead and cut it there. It's got a minute or two left. We're starting to run into court addict time. Thank you everybody for coming out tonight. Thank you for watching these. These were pretty long, but they were still interesting. Like I mentioned to Cass earlier, I'm making a video for the Judge Middleton hearing earlier. There was a probable cause hearing, and they had a 9-year-old testifying, and the lawyer was being an ass to the little girl, and Judge Middleton wasn't going to have it. And so we're gonna run that off. Linus is bailing on us. You know, we figured she would. She gets close to Houston and she just starts dropping off. But we're gonna go over there. You guys have a great night.